Happy Wednesday, everybody, with the upcoming holiday. I want to wish you all a very happy new year. This past year has been difficult in many ways. May we only hear good things. May our hostages and our soldiers come home quickly, and may peace be quickly achieved in the Middle East. In the coming weeks with the holidays, you'll find a number of the normal Friday planning videos are going to come out on Wednesday. Monday's market updates should be on the proper day, but you'll get Wednesday's version for Friday. Today, I want to start with what I like to call tales from the front line. These are lessons that we can take from some of the things I've seen recently, or even this week. Today is October 2nd, 2024, and this is your Wednesday, last day of this Jewish year, Friday planning video on Wednesday. Let me make one thing clear as I dig into this topic. I will only give tips and ideas. This topic is another one that is very, very important that you bring in your team. In this case, your legal advisor in most cases. As always, I'd love to work with them and your tax advisor as part of your team to do the best we can to provide your financial plans with the proper structure and details. Today, I want to talk about the titles that you can have in your accounts. Some are obvious and some are easy. Some are a bit more illogical, but there are good reasons to do things in a counterintuitive way sometimes. I will state again, these are ideas and tips for you to review with your legal advisor. Sometimes other options should be chosen just to achieve those certain goals. Properly naming financial accounts is essential, yet overlooked aspect of managing personal finances. The way accounts are named can have far-reaching effects on ownership, estate planning, tax consequences, and the ease with which assets are passed on to your heirs. By understanding the best practices for account naming, individuals can avoid legal complications, minimize the likelihood of family disputes, and ensure that their assets are transferred according to their wishes. Let's get into it. This past month, we have been working with a family as we deal with a trust account that was written with all of the right intentions, and legally, there may have been a reason, but for purposes of this video, the execution of the estate plan has become a chore. Quick details of the story: the trust was established by the matriarch of the family, and she named all three of her children as co-successor trustees. As I said, this is intuitive, as you would expect all to be equal. And that is fair, of course. The problem is that over the years, the children have moved all over the country. This has now delayed the next step until all of the proper signatures are in place. This delay is not welcomed by the three children, and you can imagine why. As I speak about this a lot, and as you set up your financial plan, please keep in mind the more complex you make it, it may be overly complex to execute as well. And that will often cause delays in your legacy being properly distributed along with your wishes. Sometimes complexity is called for. I'm only suggesting that you only use it when necessary. As we all know, no offense to those attorneys, including one of them in my own family, but they like to write flowery, complex verbiage. And if you push to simplify, it could save a lot of headaches. Perfect example of this, in my opinion, is what I've recently dealt with my local bank. What many of us deal with a lot these days, multi-factor authentication to protect our accounts from fraud. And yes, I do appreciate it. But when I have to spend 30 minutes on a call with a rep from the bank just to get the limit on a mobile payment system raised, I think the idea of being at a local bank that knows you, that benefit's gone. Again, I've spoken in these videos about the danger of mobile payment apps and the huge level of fraud and low level of bank reimbursement. I know, but taking it a bit too far is where I see it. You get my point. Some with the wording same with the wording in your trust. When I first moved to Chicago about 12 years ago, within the first few months, I came across a client who wanted to name her two children as co-successor trustees. One child lived in Michigan and one child lived in Israel. See where this could quickly go off the rails. It took the attorney and myself a long time to help them realize the problems that this could cause. And in the end, the plan was agreed on that met their goals while not requiring international wet signatures on multiple pages. Speaking of this, let's note that a lot can be done on DocuSign or digital signatures these days. Not everything. And this should also be considered as you set up your plan. Let's go over some other titles for accounts. Then I'll wrap up with some action ideas for you. Another chance to mention, this is where the rubber hits the road, and this is where you should discuss the pros and cons of each of the types of account titles with your attorneys. Individual accounts, of course, when the financial account is held solely by one person, it's often referred to as an individual account. These accounts are straightforward, giving the account holder complete control over the funds. However, upon the death of the account holder, the assets in the account become part of the estate, and they're typically subject to probate. Probate is a legal process where a court oversees the distribution of the deceased assets. This can be time-consuming and costly, which is why many people prefer to avoid probate if possible. To bypass probate, account holders may have the option to designate a transfer on death or TOD with the setup. The funds in the account are transferred directly to the named beneficiary upon the account holder's death, avoiding the probate process. Next one is joint accounts. Joint accounts are a popular choice for spouses, business partners, or close family members. The most common forms of joint ownership are joint tenants with rights of survivorship, and tenants in common. Joint tenants with rights of survivorship means that when one account holder passes away, their share of the account automatically transferred to the surviving account holder. This arrangement avoids probate and ensures that funds are easily accessible to the surviving party. This title is particularly useful for couples who want to ensure their assets remain available for the surviving partner. Tenants in common is a less common option for joint accounts. In this arrangement, each account holder owns a specific portion of the account. If one account owner dies, their shares do not automatically pass to the other owner, but instead become part of that person's estate. This step up can complicate the transfer of assets and may lead to probate. Before naming a joint owner on any account, it's important to carefully consider the legal and financial implications. While joint accounts can make transferring funds easier, they also expose the account to the co-owner's creditors or legal issues. Now back to trust accounts. We talked about those. Naming accounts in the name of a trust is a strategic move for individuals focused on estate planning and asset protection. Obviously, a living trust, for example, allows the person establishing the trust to retain control over their assets during their lifetime. Upon death, the assets held in the trust are distributed to the designated beneficiaries according to the terms of the trust, bypassing probate entirely. Trust accounts provide several advantages. In addition to avoiding probate, they offer privacy, as the details of a trust content and distribution of assets are not made public, unlike a will, which becomes part of the public record. Trusts can also provide protection in the event of incapacity, as a successor trustee can manage the assets if the grantor becomes unable to do so. This is an important detail that you must work into your trust. Speak to your attorney about this. We've spoken about other estate documents like powers of attorney and healthcare directives. All of this should be addressed with your estate planning attorney. One key consideration when naming a trust as an account owner is ensuring that the trust is properly funded. For the trust to work as intended, this is a big deal. All relevant financial accounts, including bank accounts, investment accounts, real estate, should be placed under the trust's name. I cannot let this opportunity to address beneficiary designations go without hitting it. If you've been watching these videos long enough, you've heard this a lot. Many types of account allow for beneficiary designation. Simple and effective way to ensure assets pass directly to heirs without going through probate. Retirement accounts, life insurance policies, and transfer on death, and payable on death accounts typically offer beneficiary designation options. By naming beneficiaries, the account holder ensures that upon their death, the assets in the account are transferred directly to the designated individuals. This method is not only efficient, but also helps to avoid the legal costs and delays associated with probate. If you remember nothing else from today, please remember this. It's important to regularly review your beneficiary designation to ensure that they reflect any life changes such as marriage, divorce, birth of a child. Failing to update your beneficiaries can lead to unintended consequences such as ex-spouses or estranged family members inheriting assets. Before we go, let's talk about some common pitfalls to avoid, which can give us some action items. There are a few common mistakes to avoid when naming financial accounts. Not naming beneficiaries is a big one. Failing to name a beneficiary or a joint owner can cause accounts to go through probate, delaying asset distribution and increasing legal costs. Outdated beneficiary designations, and again, I just talked about this. It's crucial to review and update beneficiaries regularly. Life events such as marriage, divorce, birth of children can make old designations inappropriate. Unintended consequences of joint accounts. While joint accounts can simplify asset transfer, they can also expose funds to the co-owners, creditors, lawsuits, or poor financial decisions. Failing to fund a trust. If assets aren't properly transferred to the trust, they won't benefit from the protection and advantage of the trust providing. So let's wrap this up. Properly naming financial accounts is a key part of effective financial and estate planning. The right structure can possibly help to minimize taxes, avoid probate, and ensure that your assets are distributed according to your wishes. Whether held individually, jointly, or through a trust, account ownership should align with your overall financial goals and estate planning strategy. Regularly reviewing and updating account designations and beneficiary information will ensure your financial affairs are in order and provide peace of mind for both you and your heirs. So that's your action item. Please review the titles of your accounts. Not every account needs to be a trust, but discussing the titles as part of your estate plan is very important. Talk to me, talk to your legal advisors also. Aside from those, like I described last week, who have the estate plans as getting hit by a bus after taking out the last $20 from the ATM, regardless of what you do, hopefully at least, you will have some accounts to pass to your heirs as part of your estate. I've seen way too many negative outcomes from cases where this was not thought out fully and reviewed often. Final reminder, as I quoted last week, a Greek philosopher once said that the only constant in life is change. This refers to the tax laws, estate laws, your situations, and so much more. Please review your items regularly. For now, sorry to close out the year with what may be a downer, but as we finish the Jewish year and even as we start the secular quarter four, Making life easier for those that come after us can't be a bad idea, right? Happy New Year and have a great weekend.